Okay, let's talk about the questions. We have a lot of questions. It's 12:03 right now, so I'm just going to hop right into the questions. So the first question is, we are currently revising our 30-year-old CC&Rs. We are struggling with the section regarding eligible mortgage holders. We have reached out to our management company to see if we have ever in the past or present had eligible mortgage holders ask about voting or anything in our association. No one has answers. We are researching new communities, CC&Rs, and are not finding anything about them. Are EMH, so eligible mortgage holder rights, still relevant after 30 years or at all? Okay, great question. So this is something that was done in the 80s, typically. It was written in the CC&Rs that eligible mortgage holders had to be notified if there was a change to the association documents. It's really not something that is ever used anymore in our industry, so you should be aware of that. But if you have it in your documents right now, you may need to comply with it until you amend your CC&Rs to get rid of it. The practical reality on this is that, typically what eligible mortgage holders would need to approve an amendment to the CC&Rs, or maybe they can, not approve it. And you have to provide notice to everybody who has a mortgage, that's an eligible mortgage holder. You may have to comply with that to amend the documents. So we want to get our firm involved and help you with this process and help you navigate what you do and don't have to do to comply with that. Okay, next question is from an owner. Can the board or management company add attorney's fees on a homeowner ledger when a lawsuit has not been filed? I had attorney's fees added to my ledger for a law firm letter written to me in regards to an alleged non-compliance. And that says parentheses with no CC&R rules regarding the offense. So, it really just depends. It depends on what your CC&Rs say. Do your CC&Rs, allow the association to, charge an owner for, enforcement of the documents? Most do. And I think my best advice to you here would be kind of reach out to the association and try to talk about this issue and resolve it before the attorney's fees get any higher. Okay, next question. Our bylaws call for 5 directors. We recently had 2 directors resign. Does it still require the 3 remaining directors to carry a vote or form a quorum? Or can 2 of the 3 create a quorum? Oh, good question. So you had 5. You're down to 3 now because, 2 people resigned. So 3 is a quorum. You can still conduct business. So 2 out of the 3 can make decisions. But all 3 of you need to be present at every meeting in order for there to be a quorum. Next question, number 4. Do you believe that obtaining animal DNA is a good way to detour problems with poor pet owners? Okay, so this is actually really kind of a good question. I love this. So the DNA testing is for animal feces, right? And, if we have owners that aren't picking up animal feces, sometimes boards talk about, I've actually never had a board do this. I've seen a lot of articles about this, and I've had this question a lot, but I don't actually have any active board member that's doing doggy DNA. I just don't think it's that practical. I have a dog. I walk our dog 3 times a day. And I see pet owners that don't pick up after their pets, and it's annoying, but I just get an extra bag and I usually pick it up myself and just throw it in the trash can. The problem with doggy DNA is that all the good dog owners, like us, right, myself included, are going to take our dog in there and get them, the DNA done, right? But the dog owners that don't go in and register their dog, they're never going to go in and, get the doggy DNA, kit. So when we spend the money to, send the feces to wherever to see whose dog it is, it's never, we're going to turn up as nobody because these are the type of people that don't register their dogs. So in theory, I think it sounds great. We're going to bust people on not picking up after their pets by, doing this doggy DNA thing. But the reality is this is probably not going to work. The better thing to do would be to continue to educate your owners about the importance of doing this. Have your landscaping crew and any other people that are doing inspections at your property, look for, animal feces. And if it isn't picked up, they should pick it up. Now, if you see somebody, if you have a direct report that somebody's not picking up after their pet, then you should treat it as a violation and send them a letter and fine them. Okay, number 5, can we as a board prohibit the new fiber optics company in the community? Sure, probably not. And that's kind of a loaded open question, but I don't think that, usually there are easements that are on your plat map that would allow them to install fiber optics, but it's a case-by-case basis. Now, I'm guessing the reason why you want to prohibit them is because possibly they may be, tearing up your roads or whatever. They have to put it back exactly the way they found it. So if you have a company that's coming in like Cox or anybody, and they don't put things back to exactly the way they were before they came in and installed something, we can require them to come back and do that. Question number 6. A shed which was installed by a prior owner on a lot has been argued by some as being in violation of the governing documents. ARC application was never submitted. The board has not ever taken any action. How long after a violation has occurred can a board delay requiring remedy of the violation before such remedy becomes unenforceable in the eyes of the law? I would say if it's been there for more than 3 years, forget it. You're not going to be able to enforce it because and there's a waiver, we didn't enforce it against that person. Also, you said prior owner. So why wasn't this picked up at the sale? That would have been the best time to pick it up, the violation, and notify the buyer of the shed being in violation at the time of the sale. Okay, number 7, our master board has removed historical financial information from our website, annual audits, annual budgets, and past reserve studies. They also removed selected, approved, open meeting minutes. Is this legal? Well, I don't know. I mean, are they doing some housekeeping because there's just too much stuff on there? I think that's totally fine. Is there a reason? I'm guessing there probably is. So maybe what you might want to do is just ask. I mean, you don't want to have too much stuff on there if it's becoming too overloaded. So I get that. I mean, I totally get that. So, is it like a intentional, like deep fake, deep dark state type thing? I doubt it. But it could be, you never know. So I would just ask some questions. And if there's something that you're looking for, you always can make a records request too. So is that legal? Yes, they have the right to regulate what's on the association's website. Okay, next question, number 8. Our board approves a new budget every October. We have line items for plants and trees. How is this typically used by the board? Does the landscaping committee typically get access to this? I know it depends, but what is typical? So it is not typical to have a line item on the budget for plants and trees, in my experience. Maybe there's a landscaping budget, or something like that. And it's typically in the discretion of the board. I'm thinking about my association. We have a line item to, use money something dies, to replace it or to upgrade, and the board makes the final call on how that money is spent. So typically when you say, how is it used by the board? It's used as needed. And does the committee get access to this money? Usually not. They can make recommendations, but the board's ultimately the one that makes the final decision. Question 9, is it okay for a board member to hold two positions, such as president and treasurer, because we cannot get 2 people to accept the responsibilities? So if your bylaws don't prohibit that, that's fine. The only thing I would say is president and treasurer, that's 2 big jobs for one person. I'm not saying they can't do it if it's not prohibited by your documents, but that's a lot. What you might want to do is do like president and secretary, or treasurer and secretary versus, 2 sandbags that are heavy, president and treasurer. Those are pretty hard to do at the same time. Okay, next question, number 10. What is the legal authority or pushback HOAs have on enforcing street parking restrictions? This is a non-gated community built prior to 2015 that does have street parking restrictions in CC&Rs. Okay, so we have a great blog that we're going to be sharing with you on parking violations in an HOA or condo. Okay, so a couple things. So if your community is non-gated, built prior to 2015, I don't know if it is the streets are dedicated to the city or not, but I'm assuming that they are. And you have street parking restrictions stated in your CC&R. So there's a law that went into effect last year that talks about, an association's ability, a planned community's ability to enforce on-street parking if the streets are dedicated to the city. And so, the legal authority is right now, you can do it. You can continue to enforce the parking restrictions. But in 2026, by 2026, if your board wants to continue that, if your planned community and this community and the streets are dedicated to the public, you're going to have a vote of the membership to keep doing that before, this certain date in 2026. So you want to look into that. You may want to check out our cheat sheet on the legislative update from last year, 2023, for more information on that law. Okay, next question, number 11. Can the board meet officially or unofficially to discuss and gather info on an issue such as changing gate codes, updating the CC&Rs? After discussion and gathering info by the board, we would then discuss at an official meeting with the community. Okay, so the question is, can the board just meet to discuss information like on gate codes, updating the CC&Rs, and then take it to an official meeting? So yes, but it has to be less than a quorum. If you don't want to notice the meeting as an official or unofficial meeting, it only can be less than a quorum to not violate the law. If you want to do it with a quorum, then you just notice it as an official meeting. Question 12, all of our condominiums have a garage, which is the most convenient place to park to access our condos. We have some visitor-only parking and some parking open to residents and visitors. Some handicap spaces are in the visitor-only areas. Can we ask residents to not park in the visitor-only handicap spaces because their garage is the best accommodating place to park? This is like a loaded question because I'm assuming that you have a handicap resident that's parking in a handicap space. And that is something that I think is going to be okay and that you can't prohibit. So I think on this one, if you're going to enforce it, you definitely should reach out to our firm to discuss it further, give us more facts. But I think in this case, based on the limited facts I have, I would not go there. I would not, tell that handicapped person to not park in the handicap space in the visitor parking. Okay, question number 13. In regards to executive meetings, a resident lawyer has started legal action against us, and he feels that we should disclose everything that is discussed in executive session. We have sent redacted minutes, but he still wants more. What, if anything, are we required to allow this resident to see? It's always fun to have lawyers in your community, right? Who are, saying that they, know the law and are going to sue you. Okay, so you really shouldn't be disclosing everything that is discussed in executive session. You have no responsibility to do that as long as you're focused on the executive session topics and you're not going off on other topics. He can't have any discussions from the executive session. So that's the bottom line. Even though he's a lawyer, even though he's trying to sue you, as long as you're following the law and talking about executive session topics in executive session, you don't have to give that person anything. Okay, next question, number 14, from one of my favorite clients in the West Valley. Does an HOA board have a responsibility or obligation to represent homeowners in matters of concern that originate beyond the property boundary of the community? Example would be homeowner concerns about possible crime from a proposed convenience store whose building permit is under consideration by the city. Or homeowner complains about an unpleasant owner whose source is believed to be a milk processing plant in an industrial zoned area. Or homeowner complaints about road noise from a nearby multi-lane highway. All these issues are regulated by federal, state, county, or city government agencies to which any citizen can express his or her concern. But does the HOA board have the duty to be the principal champion for association members in these types of outside the walls matters? So I would say no, the board does not have the responsibility or obligation to get involved in really any of the examples that you've given me. However, there are times where maybe the board would get involved, but you don't have to. Okay, so for example, let's say that, I've seen some boards get involved, like let's say that maybe the board doesn't want a certain thing, to go in and there's some public feedback, that's allowed at city council or something. I mean, some examples I can think of is, back when marijuana became legalized in Arizona for, a lot of associations didn't want to have these, medical marijuana, dispensaries, right, in a strip mall right next to their association. And so, maybe the board was sending a letter if there was like a lot of smoking or something and to the owner of the facility. But you're not obligated to do it. And I think what you can do is encourage them to, band together with other residents. And if the board is in favor of it, you can also sign off on it. Like, hey, we think there is an unpleasant odor, but you're not required to. I think that's the most important thing. And remember, if you're looking at what you're required to do, you look at the CC&Rs, you look at state law, and state law doesn't require you to get involved in any of these things. Okay, next question, number 15. I know that towns do not have to follow state or federal guidelines. Wish I would have realized that before now. So what can be done when HOAs inflict horrible CC&Rs? Move. That's one option. Run for the board. See if you can make positive change from the inside. Try to get an amendment passed to the CC&Rs that you don't like. Okay, question 16. Our bylaws are silent on ballots. Our community has had open ballots since its inception. We wish to change the ballot procedure to make it a closed or private ballot, secret ballot. Given the bylaws are silent, can our association change to closed ballots without a vote of the membership? For example, can we simply clarify closed ballots in the same way we clarify rules without an upper vote? Good. I mean, one thing that I'm going to say, I don't know why you want to go to a secret ballot, but it is kind of a hassle. And lots of times homeowners don't understand the concept of a secret ballot and they write their name on the ballot, which could potentially invalidate it. And it makes it more difficult for people to vote, or it's supposed to be a double envelope system with a secret ballot, and, they don't follow the directions and end up spoiling a lot of ballots. I mean, so I guess your board could, say that they want to have it be secret ballot, but unless it's and you can enforce that, right? You can ask people to do it that way, but unless it's in your bylaws saying that you have to do it, an owner could say, no, I'm not complying with that. I'm going to write my name on it, and there's not much you can do about it. So, I mean, probably the best advice I would be is I don't really think secret ballot's a good thing. So I wouldn't encourage you to do this. And second, if the board wants to do it anyways, you certainly have the right to set up the ballot that way. But if somebody doesn't want to comply, there's not much you can do about it unless you amend your bylaws to change it. Okay, question 17 from a manager. I have a new board member who continues to take photos of a homeowner's children, even if they're just playing on the sidewalk. They have not done any damage to the common area, but they do play outside a lot. He takes pictures and posts them to a Facebook page that he runs for the community. He has also banned this homeowner from the Facebook page. He's new, so I'm trying to educate him. I used your cheat sheet regarding social media, so thank you. That's nice. But am I correct in thinking that this may open the association to possible harassment issue if he continues to do this? Yes, and yes. This is problematic in many different ways. Okay, A, he shouldn't be taking pictures of children and putting them on social media. That is a big no-no. Second thing is he running the Facebook page for the community? That concerns me right there, because you guys should have some sort of, policies and procedures as to what can and can't be put on there. And I don't think putting those on the Facebook page for the association or any Facebook page saying, hey, these kids are violating type of thing is a good idea. The better way to handle that would be to contact the parents. But I mean, again, kids are kids, they're allowed to play. So I haven't heard anything, about them playing on the sidewalk that is making me think, oh yeah, this is a big violation. We need to pursue it. I'm thinking no violation. So, I think that we need to give some education to this person about, hey, you can't do this, and give them some guidelines as to what can be posted. Okay, question number 18. Our CC&R's state garbage and refuse facilities, containers, and the like shall be attractively screened and camouflaged in such manner as to conceal them from the view of neighboring lots, residential units, property, roads, or street. Our landscapers recently trimmed some screening bushes such that several refuse containers are now visible. Some of our members received violation notices as a result of the trimming and are contesting the violations. Should the association waive or not violate members in this situation? I guess the question I have for you is, is the screening of the, trash cans, is it common that it's by bushes and trees or whatever, and the trees are going to grow back? So, I was thinking more that it would be like screening and camouflage would be more like building a wall around it. So you probably know the answer to that better than I do. If the screening and camouflaging that's, allowed is to have, trees and bushes or whatever, then they're going to grow back. I probably would not violate them. But if this is the type of thing where maybe you had some overgrowth and they were using it to camouflage it, but really they should have been building a wall around it or something, that you may not want to waive it. Okay, question number 19. Let's see how many questions we have left. We have 28 questions total, so not too many left. If a property management hasn't required previous board to enforce CC&Rs in regard to exterior architectural changes, and the new board is noticing changes made but owners hadn't requested nor received architectural approval, what can be done now that a change is complete? This is a very tough question because I don't have all the facts, but you can send a violation letter. You can work with the homeowner to try to fix it so that it would be approved. You should be reminding your homeowners now in advance through frequent communications like, hey, no changes, no architectural changes without getting approval first. So on the person that's already done it, open lines of communication, maybe send them a letter, see if you can work it out with them amicably. I don't know how serious the change was, but you might be able to go the legal route. Although I don't know because you haven't enforced it in the past. We have to weigh a lot of different things. Okay, question 20. A member of our 3-member board is somehow under the impression that if all 3 of our board members vote to approve a proposal by email, then we do not need to otherwise follow the dictates of the open meeting state statute, announcing a meeting 72 hours in advance, etc. Okay, that should be 48 hours. That unanimous approval via email is somehow a special way to gain board approval outside of a regular meeting. I have never found such an exception in state statutes. Please clarify. Okay, so I am in agreement with you that using email to make decisions outside of a board meeting is a violation of the open meeting law. There are some exceptions. If it's an emergency, I think you can use an email to make a decision. But I know a lot of management companies are saying, hey, this is okay because it's in the Nonprofit Corporation Act. You can make decisions by unanimous written consent. But it directly conflicts with state law because open meeting law says you have to make decisions in a board meeting. And there's at least 1 or 2 administrative law decisions that say you can't make decisions by a unanimous written consent. So I would shy away from that practice. I think it does violate the law. Question 21. Are associations required to provide to homeowner information such as violation, fine, count information of other homeowners? So what the law says is that we can withhold from discovery, so we can withhold information that might contain personal information about an owner, or if we're involved in a lawsuit with the owner. So I don't know, based on the facts here, I don't think, that the violations and fines, could be considered personal information, although it may not be. It doesn't sound like there's a lawsuit here either. So here's kind of my golden rule. So I'm fine with you sharing information about what's in the file, right? So if you've got, letters in the file that might be violations or fines, I'm fine with you sharing that. I think you could argue that it's personal information if you wanted to not share it. I'm not okay with account information. So social security number, bank account numbers, phone numbers that might be like, cell phone numbers, personal emails. I'm not okay with that because I do think that's personal information. You cannot give that to the other side. I would probably, if I were advising your board, I would push back at first and say, no, you can't have this information pursuant to state law. If they push back and say, well, I think we can have maybe like with the content of the file that's not personal information, then you may have to provide that. Okay, question 22. Who should approve the annual meeting minutes? The owners at the next annual meeting or the board at their next meeting? So annual meeting minutes are approved annually. So the next annual meeting, you will approve those annual meeting minutes from 2014. You'll approve those at the 2015 annual meeting. Now, the board may want to take a spin and look at them right after the annual meeting, just look at a draft, but they're not voting on them. Question 23. As a new board member, other than your website, are there any other things that I should read? Is there a good book or a good website? I would look at the Community Associations Institute national website. Just type in Google CAI or Community Associations Institute. And make sure that you get the national one because they have a whole bunch of resources there. I think that would be the other place that I would go to. Question 24. If a board has D&O coverage and a majority of the board agrees not to enforce most of the CC&Rs and rules, like parking, styles of vehicles not permitted, trash can, short-term rentals, does the D&O continue to cover all board members if an owner sues an association and or board members individually? Should this board decision be a formal vote in an executive or open meeting? Well, okay, so your D&O coverage is probably going to be covered on something like this, whether the board's making a mistake and not enforcing it or whatever. So you're probably going to have D&O coverage no matter what. But what I don't like here is taking a formal vote saying we're not going to be enforcing our CC&Rs because you really shouldn't be doing that. You should be changing your CC&Rs if you don't want to enforce them. Okay, question 25. Should board members provide their board email to community members, or should all communications flow through the property manager? It really depends on how, in my opinion, how the board wants to run it. I don't think there's a correct answer. Sometimes the president puts their email out there. Sometimes they don't. If you put your email out there as the president, you can have a lot of emails. And some presidents are okay with that. Most of our clients just set the management company email. Okay, last 3 questions. There is a solid case regarding fair housing violation against our HOA. If the AG brings a lawsuit against the association, what kind of impacts may the 16 owners in our community face? That worries me. It's a concern. Like, if there's a solid fair housing violation case, you should try to settle that. The AG's office typically engages in conciliation, which is like a mediation through the AG's office. And, you should resolve it and apologize. If let's say that you don't, and this continues to escalate and they file a lawsuit and now you get a judgment against you, it may or may not be covered by the insurance. So if it's not covered, then take whatever the expense is and divide it by the number of homeowners, and you may have to pay your fair share, which is scary. So I hope it doesn't get to that point. Try to resolve that. Last 2 questions. 27. What financial information should be made available to community members beyond the balance sheet and income statements? So when you say shall be made available, like on a monthly basis, are you saying, or like if they request it? Honestly, I would just put the balance sheet and the income statements on the website. And if somebody wants more, like they want to see a bank statement or they want to see the year-to-date budget or something, then provide it to them. Last question. At our recent annual election, a board member candidate posted a bogus message on social media telling residents that they could change their vote if they wanted by picking up a paper ballot at the office and dropping off the ballot in the ballot box. As a resident of Maricopa County, I'm a little sensitive to any type of election disruption for any election. What is the recourse for the board on this issue? I don't know. Problematic, but if your ballot, like the ballot that I write for associations, it says right on the face of the ballot, this is non-revocable. So if you have that or irrevocable, which means that even if they cast a second ballot, it wouldn't have been counted. I think probably I would talk about this as a board and just remind everybody that, like, hey, you shouldn't be doing stuff like this. Of course, this person was a candidate at that time. But explain to them that, the ballot is typically irrevocable. So by putting that information out there, it just created confusion and more work for everybody. So it wasn't a good thing to do, and they shouldn't have done that. But people are weird, and sometimes they do it no matter what. So even you may tell them not to do it, they continue to do it. Just know your rights on the ballot. Which one should be counted is the one that's dated first. Okay, we are at that time where we're at the conclusion. We covered a lot of ground today. So thank you so much for being here. We had over 145 on Zoom people here today, which is awesome, and many more on Facebook Live. Thank you again for joining us today, and I'd like to give a special shout out to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their continued partnership. And a high five for you guys getting a representative, or at least some representatives from each city here today, which is awesome. Our firm recently released the class topics for July through December 2024 for our virtual HOA Condo Academy classes. We have those all posted on our website now, so we're just going to keep on moving forward. We planned a great curriculum for the second half of the year, so I encourage you to take a look at that. Don't forget, our next live virtual First Friday event is set for Friday, June 7th at 9 a.m. Next month, we have our sixth class of 2024 for the virtual HOA Condo Academy is set for Tuesday, June 18th at 11 a.m. The topic for next month's class is going to be untangling the web, navigating politics, and frequently asked questions in HOAs and condos. So I hope that you will join us for this class. It's going to be all about sticky situations, navigating politics, and how that all works in an association. And we're going to also address our firm's most frequently asked questions. So I hope you'll join us for that class on June 18th. Take care, everybody. Have a great rest of the month in May, and look forward to seeing you at our future classes. Take care. Bye.